Principles of the Islamic Law. Original language Arabic by Professor Muhammad al-Zuhaili. Second print. Darul Uloom, Dubai. The book has come in several chapters. The chapters, as far as it could be conceived, almost follow the traditional categorization of the topic of this area of the Islamic law. The chapter 1 is dedicated to a discourse on the nature of what is called the discipline of the principles of the Islamic law. It presents definitions offered thus far and analysis of this next to what is preferred by the author. Other issues of concern in this chapter are the precise subject of the discipline as well as the advantages cultivated in extracting law through mastering the subtleties of this discipline. Lastly, an account of the history and development of the discipline is exposed in some detail. The second chapter is an examination of the universal sources of the legislation in Islam. The book, which is an expression of the Quran in the language of Muslim legal scholars, is the first and the primary source. There are discussions and arguments relating to the ways through which the Quran can be understood, particularly as far as the law is concerned. These are briefly referred to in this second section, awaiting further more detailed arguments later. As-Sunnah is the second most significant primary source. It encompassed words, actions, and ratifications of the Prophet Muhammad, peace be upon him. The third source is Ijma. It means, among other things, agreement or consensus among Muslim scholars. There is not, however, a single view on Ijma, and the author has endeavored to offer a spectrum of views on the subject. The fourth source to which allusion is made is deduction by analogy. Yet, whether or not this is a formidable source is a matter of contention. The author attempts to shed light on various aspects of this topic, including the contentious areas as well as the proposed and adopted structures in various schools of jurisprudence. The fifth source is istihsan. This is an action of deduction by analogy whose underlying logical structure can only be immediately discerned by the legal scholar who has offered an opinion based on istihsan. The sixth source is Masalih al-Mursala. This is plural for general interests whose roots of legitimacy do not derive immediately from the primary sources, but rather from the judgment of the legal scholars with which, or rather from the judgment of the legal scholars which ought to be based on Islamically sound sense. Arguments ensue here as regards to the legality of this source and its applications. Then the seventh source is istishab, which means whatever was said to be seen as established in the past will remain valid as long as there is no reason to indicate otherwise. An example is the ownership, which will remain valid until there is a proof suggesting its subtraction. The eighth source is the custom and common sense. Again, legality and qualifications and the categories are discussed. The sayings of the Prophet's disciples constitute the ninth source according to the author. The section tries to offer a view on who might be considered a Prophet's disciple. The 10th source is the law of those who came before Islam, by which it is meant the religions acknowledged by Islam. The 11th source is the blockage of pretexts, which mean prohibition of what is lawful but help cause unlawful results. An instance of this is taking books to the examination hall. At the end, the author briefly refers to other sources with lower level of acceptance among legal scholars. The third chapter is on the objectives of the Islamic law. The chapter first mulls over the topic of determining these objectives. Then there follows an argument over the legality of the objectives and the interests they achieve. A classification of the objectives based on the interest they accomplish come next. The interests are divided into the essential, auxiliary, and complementary ones. The essential interests, for instance, are religion, life, rationality, reputation, offspring, and positions. The fourth chapter offers a survey of what might be called a legal decree. This kicks off with an examination of definitions. The categories of the decrees assigned by the Islamic law are as following: obligatory, desirable, prohibited, undesirable, neutral. The fifth chapter is allocated to a survey of the problem of interpretation and the implication of words. The sixth chapter offers an illustration of what it takes for an individual to attain a level of competence sufficient enough for forming authorized judicial opinions. The last and ninth chapter deals with the conflict of both jurisprudential and legal regulations and decrees.